Hello students, I am Professor Sandeep Bodke from Lokneti Gopinathji Munde Institute of Engineering Education and Research, Nashik. Today we are going to discuss the topic of arbitration. First of all, we will discuss the definition of arbitration. Arbitration is the process in which dispute is submitted to an impartial outsider who makes a decision which is usually binding on both the parties. So there are two parties which have come across a dispute, and an impartial outsider or expert who makes a decision after reviewing the situation. An arbitrator enforces his own point of view on contending parties, and the opinions of the participants are not given any predominance. It is a judicial process, and the award of the arbitrator is binding, and it rests on equity and justice. So there is no scope of compromise. Qualification of arbitrator. Arbitrator can be a person who has expert knowledge in particular branch of profession and the matter in dispute. He must be impartial and unbiased. He must be unquestionable character, high integrity, and unshakable faith in justice. Generally, a person not below the rank of retired superintending engineer gets selection as an arbitrator. Duties of arbitrator: to administer oath to the parties and witness appearing, to act judicially and impartially, to put necessary interrogations to any party to the dispute, to determine by and to whom the cost of reference and the award shall be, to award interest, to fix amount, mode and time of payment. So the arbitrator holds the hearing, issues the decision and grants award, determines the facts, applies rule and law. Here is the flowchart of arbitration process. First, the case is filed. First, the case is filed. Then, arbitrator is selected. Here is the arbitrator selection process. Then, preliminary hearing and scheduling order is placed. Then, discovery process. After that, hearings and mediation. Then, arbitration hearing is there after this. Then, post arbitration briefs is laid, and final arbitration award is made. So this is the simple process of arbitration. There are two types of arbitration. One is voluntary. First is voluntary and other is compulsive. So first we will discuss the voluntary arbitration. It implies that there are two contending parties unable to compose their differences by themselves, agree to submit a conflict or dispute to an impartial authority whose decision they are ready to accept. This is called as voluntary arbitration. What are the essentials of voluntary arbitration? The voluntary submission of a dispute to an arbitrator, the subsequent attendance of witness and investigations, the enforcement of an award may not be necessary and binding. Voluntary arbitration may be specially needed for disputes arising under agreements or contracts. Then next type of arbitration is compulsory arbitration. Compulsory arbitration is one where parties are required to accept arbitration without any willingness on their part. When one of the parties to an industrial dispute feels aggravated by an act of the other, it may be it may apply to appropriate government to refer the dispute to an adjudication machinery. Then essentials of compulsory arbitration. The country is passing through grave economic crisis. Industries of strategic importance are involved. Parties are ill-balanced. Compulsory arbitration leaves no scope for strikes and lockouts. It deprives both the parties of their very important and fundamental rights. So we are coming to the end of the presentation. We will discuss the advantages and disadvantages of arbitration. Choice of decision maker with expertise. Then speed of the judgment is very high in case of arbitration. Lower cost. It is flexible. Confidentiality is maintained. Less formal than court. And preservation of business relationships. These are the advantages. And what are the disadvantages? Disadvantages of arbitration are limited recourse, even uneven playing field, lack of transparency, cost parties pay for arbitrator and agency, limited rights of appeal, fewer means to challenge award, and lack of formal discovery. These are the disadvantages of arbitration. Thank you.